Welcome, it's San Diego probate lawyer Kristina Hess, and in this video I'm talking to you about how to prepare the executor of your estate. As you go about putting together your will or your trust, it's really important to think about who that person is going to be that's going to manage the estate when you're no longer here. So just to get some terminology out of the way, if you have a will, then that fiduciary is called an executor, and if you have a trust, then that person's called a trustee. For the purpose of this video, I'm going to use those terms interchangeably, but I'm going to refer to the person as an executor. But just know that if it's a trust, then that person's a trustee. Alright, so you are going to want to thoroughly prepare that person. The first thing that you want to do is make sure that the person that you're thinking about putting in your plan as your successor, executor, or trustee, make sure that first and foremost that they want the job. And that in addition to wanting the job and being willing to serve, make sure that they are equipped to actually do the job. Being a successor, trustee, or executor is a very important role and job, and they are a fiduciary, and that means that they have to look out for the beneficiary's best interest. There's a lot of tasks involved: marshaling assets, getting appraisals, filing taxes. If there's any court proceedings, then they'll need to be the representative for the court proceedings. So it is a very important job. If you have a fully funded living trust, then that will make the job much easier for them. But even then, there is some administration that needs to happen. So first and foremost, make sure the person that you'd like to choose, or the people that you'd like to choose, are able and willing to do the job. Sometimes people don't know who to choose. Oftentimes my clients are stumped. They say, you know, we just really don't have anyone that could serve in that role that we would trust with our money and our assets after we're gone. If that's the situation, then we can recommend private fiduciaries, or there's banks that have trust departments and professional fiduciary services. You might have to hire an outside third party. Sometimes accountants and other professionals will also serve as trustees, so you'll want to explore those avenues as well. Sometimes you might think it's a badge of honor to be nominated to serve in someone's plan, but the truth is the person might think it's a huge burden. So you just want to check in with them and make sure that they are able and willing to serve. And then the other thing that you're going to want to do is make sure that you have sufficient backups lined up. So you're going to want to have one in line, at least two successors lined up in case that they're unable or unwilling to serve when the time comes. And then once you've chosen your successor executors, discuss the contents of your plan with them. So remember the old days from the movies when, you know, there would be a death in the family, and then everyone gathered around the table and went to the lawyer's office, and then there was the reading of the will, and up to the point of the death and the reading of the will was kept secret, and nobody knew what was in it. And then there were all these surprises about who was getting what and what was happening, and then people were upset, and it was this big production. Don't do that. I really don't recommend it. Warren Buffett even has been quoted as saying that he discussed his estate plan and discusses his estate plan with his children now while he's alive. He explains to them, you know, how much is given to charity and charitable organizations, but the bulk of his estate is going to charity. His children are involved in the organizations now while he's alive. So I encourage, if it's good for Warren Buffett, it's good for you. I encourage you to discuss your plan not only with your successor executors, but also with your family members and your loved ones who may be beneficiaries of your plan. Some people might be afraid to do this, but it's easier to it's easier to smooth over ruffled feathers now while you're alive, and to prevent bad feelings later. It's also easier for your executors to know about potential problem areas that might arise later. Maybe there's beneficiaries that have drug or alcohol problems, and you put contingencies in your plan so that if there was a situation where there was an addiction or dependence on alcohol or drugs, that the money wouldn't flow to them. The executor needs to know this, and maybe the beneficiary with the problem needs to know this, so that you can encourage them to seek out a path of wellness and recovery. Advanced planning helps avoid surprises later on. And so this can really help smooth family dynamics. If maybe you chose one child to be the successor trustee and not another, have that conversation. Explain your reasoning. Tell the child who wasn't chosen how much you love them and respect them and how amazing they are, but that their sibling was more qualified to serve in this role, because of X, Y, Z. These conversations can really go a long way, because once you're no longer here, the conversation can't take place. And the hurt feelings and the things that go on with the loved ones once you're gone can be very deep and profound. So I encourage you to have the difficult conversations now. If you need the help of an estate planning attorney to facilitate a family meeting, then that's something that we provide for our clients, and perhaps in your local area that's something that your attorney could provide as well. But again, make sure you've chosen good executors who you trust and who are equipped to perform the important job of being executor or successor trustee of your trust or your estate. Make sure you have a conversation with them, that they're prepared, that you provide them with your lawyer's contact information. Perhaps you even want to provide them with the estate planning documents themselves so that they've got an extra copy. And then have the difficult conversations now. It's worth it. It's worth it. Your legacy is worth it. So I encourage you to take the steps mentioned today. This has been San Diego Probate and Trust Attorney Kristina Hess of KR Hess Law, and I hope you found this video informative. Stay tuned, like this page, stay tuned for this channel, and also check us out on Twitter, krhess.com. Thank you.